duly convicted. So have you served any time for something that you were not duly convicted?
We are invoking Article 1 and Article 3.
That's a violation.
We're invoking Article 3.
Section 3. Every person may freely speak, write, and publish his sentiments on all subjects, being responsible for the abuse of that right, and no law should be passed to restrain or abridge the liberty of speech or of the press. Has anyone reduced your ability to speak freely on any subject? They haven't reduced it or told you not to say certain things or not to communicate with someone.
Well, she's been held at all. They're restricting her.
Okay.
They've done that. Has been done.
In all criminal prosecutions or indictments for libel, the truth may be given in evidence. So I see that you can give the truth as evidence in Wisconsin. And it shall appear, if it shall appear to the jury that the matter to be charged as libelous be true and was published with good motives and for justifiable ends, the party shall be acquitted, and the jury shall have the right to determine the law and the fact. The right of the people peaceably to assemble, to counsel for the common good, and to petition the government or any department thereof. Is that not what we're doing right now? Shall never be abridged. So they can never abridge, make anything less of our peaceably assembling here for this purpose. And this purpose we are conducting this grand jury. Section 5. The right of trial by jury shall remain inviolate. They cannot violate it. And shall extend to all cases at law. So have you been given a trial by jury, or has it been something else they've been conducting against you?
But we got to brief the jury on the case a little bit too.
Oh, okay. I was going to let them know about this because they need to know this first before we talk about the case.
That's perfect.
Okay. The right of trial by jury shall remain inviolate and shall extend to all cases at law without regard to the amount in controversy, but a jury trial may be waived by the parties in all cases in the manner prescribed by law. You did not waive your right to a trial by jury. Section 6. Excessive bail shall not be required, nor shall excessive fines be imposed, nor cruel and unusual punishments inflicted. Can you show me what happened to your wrist? And that was for what purpose?
Handcuffing.
That was for the purpose of handcuffing you. Because what? You're a chattel? You must be handcuffed?
Yeah, I got that.
Section 7. In all criminal prosecutions, the accused shall enjoy the right to be heard by himself and counsel, to demand the nature and cause of the accusation against him, to meet the witnesses face to face, and have compulsory process to compel the attendance of witnesses in his behalf, and in prosecutions by indictment or information, to a speedy public trial by an impartial jury of the county or district wherein the evidence shall have been committed. Wherein the offence shall have been committed, which county or district shall have been previously ascertained by law. So we were right. We were right by this prosecution. We were right. Section 8. No person shall be held to answer for a criminal offence unless on the presentment or indictment of a grand jury. Have you been charged with a criminal offence?
I haven't been charged. I've been allocated.
You've been allocated, you've been incarcerated. No person shall be held to answer for a criminal offence unless on the presentment or indictment of a grand jury. except in cases of impeachment or in cases cognizable by justices of the peace. We have a justice of the peace. You're a justice of the peace. So if you cognize, that means that you would see and know. It's from the Latin cognoscere, to know. So you would be qualified. You are a justice of the peace, and you would know whether or not there is any person that should be held answerable for a criminal offense, because you're a justice of the peace. Right here. Okay. So you can with authority instruct the rest of us, your official opinion as the justice of the peace, as to whether or not this is the case, right? No person shall be held to answer for criminal offense unless on the presentment of it or indictment of a grand jury, except in case of impeachment, or in cases cognizable by justices of the peace, or arising in the army or navy, or in the militia, when in actual service in time of war or public danger, which is not the case right now, mate. And no person for the same offense shall be put twice in jeopardy of punishment. Nor shall be compelled in any criminal case to be a witness against himself. All persons shall before conviction be bailable by sufficient sureties, except for capital offences, when the proof is evident, of the presumption great, and the privilege of the writ of habeas corpus shall not be suspended unless when, in cases of rebellion or invasion, the public safety may require. Now, I think that we should use this. We need to use a writ of habeas corpus be served on these people for kidnap, because they have kidnapped the children of Crystal Mueller, and we're going to demand that they be produced. Section 9. Every person is entitled to a certain remedy in the laws for all injuries or wrongs which he may receive in his person, property, or character. He ought to obtain right and justice freely and without being obliged to purchase it. Have they made you sign a bond in order to experience your freedom?
Yes. They forced women to pay a $5,000 cash bond and in addition a $5,000 co-signed signature bond.
This is indeed in direct prohibition under our Constitution, Article 1, Section 9. You be my witness. And without being obliged to purchase it completely, and without denial promptly, and without delay, comfortably to the laws. Conformably to the laws. Section 10. Treason against the state shall consist only in levelling war against the same, or in adhering to its enemies, giving them aid and comfort. No person shall be convicted of treason. Some of these blokes need to be convicted of reason, I think. No person shall be convicted of treason unless on the testimony of two witnesses to the same overt act, or on confession in open court. I think you need a remedy under law so that I can read a bit better for you, mate. So I will apply the appropriate remedy to do you justice.
Conditions of Brandon's bond were that he had to go to work today, so he couldn't be here. Or he would...
On condition.
It was his first day of work
First day of work.
in his new job.
Section 11. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now I have seen. Can you produce the evidence of there is a warrant that you've been given? Is that not so? I've seen this warrant, and I have tested it by what little understanding I have of the law. And my understanding of the law, that a warrant must have signed a witness affidavit that it has. And not only that, but under law, they cannot serve this warrant against her. And by the way, where is the affidavit? There is no affidavit. This is fallacious. This is fallacy. This is absolutely a travesty. This is injustice.
In
This is
addition,
fraud.
They didn't give it to us, they didn't serve it to us
It
until
no.
after they were leaving the house.
This
So-
is not the correct time that we were served. It was served at 11 o'clock after they were completely done destroying their home.
Oh, well, by law, my understanding is that a search warrant cannot be acted upon until the witness, you go before the judge, and the witness is tested to see that the claim is valid. They cannot search or seize or do anything against her. They cannot do that until the written affidavit. And where is it? Where's the written affidavit? There's none. You see, there's none. Okay? Until that has to be tested for truth, for veracity, under the rules of truth, fact, and evidence under the law. And that's not being done. Instead, they have violated this. The right of the...
Christmas Eve of last year, my baby had a near drowning incident. I had swept the floor in the kitchen and the bathroom in a rush. Upon coming back into the bathroom, I seen that he had fallen backwards. And as I picked him up, he began to turn red in the face. And then he stopped breathing. This 2 times on his back. And as I did that, he had peed and pooped himself. He was still continuing to get worse, and then he stopped breathing. So I did put him on the floor, and I did 3 repetitions of CPR. He came to breathe, and I called 911. He was med-flighted that night to Madison. A few weeks after that, our family had all gone through turns of the flu. My turn, unfortunately, I was sleeping, and Brandon was in the living room with kids, and Kelly Olson, a social worker from Adams County, and Mark Bitsy, an investigator, showed up to talk to Brandon. And Brandon had informed me that they were present after they left and said that if I had any questions to give them a call.
What time of day was that?
Crystal, could you just say in your words or show them that paper where the American Hospital Association in Madison determined that there was no evidence of drowning? 0. That came from the Hospital Association in Madison, American Hospital Association at the university. It states specifically, according to the last in the paragraph, and that there is no evidence of any drowning.
Could you pass that around to the grand jury so that we look at that document?
Right.
Sure.
It's actually underlined.
That was in the morning. Or morning.
Morning hours. They never came more than, they stood at the doorway the whole time that they were there, from my understanding. A few weeks after that, I received a call, and they had asked me if I could come into the office and talk to them. And I said I'll go in there alone and talk to them. And they had asked me some questions.
University of Wisconsin.
And I had answered honestly, saying that I had swept the floor.
How much later, Crystal, was it before they came back? 2 weeks, 3
2
weeks?
to 3 weeks, I believe. Since then, they had gone into school without my prior authorization, questioned my 10-year-old son.
Did they take him out of the classroom?
They did, and then they told me that they had to do that for a follow-up visit, and told me that in order to close the case, they also had to do a follow-up visit with me and see my 1-year-old and my 2-year-old son. They had an appointment set up for me Monday morning so that they could answer any questions I had about what they had asked my son in school that day, because they had told him directly, do not tell your mother we were here. So upon going in on Monday morning...
So they told lies.
They
Did-
They have told many.
Both
Did
lies.
they also tell your son not to say anything about what they had said? Not only that they weren't there, but not to say anything to you about what was said.
You don't know for sure.
But I don't know.
Did they reveal the children did not? Well, thank you for your
And just tell a child not to say that they were there, as we know.
Yeah, that's the same thing,
Yes.
Right.
But was she going?
He said, she's really good at this. They shut them in the room as they started to cry and